Well, hello friends. Welcome back to the channel, WSIB Truth Matters with Joe Machado on this beautiful Tuesday afternoon. The sun is shining, it's beautiful weather, and summer is here. It's amazing. As you all know, it's my favorite time of year. But I'm sure you don't want to hear me talk about the weather. So today I'm going to do a video that I've been looking forward to doing for a while. And it's another big win for injured workers. And even though the fat cat's down at 200 Front Street in their lofty offices scheming to try and screw the worker again, they got a smackdown from a three-judge panel in the Ontario Superior Court. Yeah, he said, nah, not in my courtroom. Not going to happen. Some probably think this is a small win. It's a huge win for injured workers. It's a huge win. And I'm going to talk more about that decision. For those of you who are subscribers and frequent the channel, you know that I'm a straight shooter. I tell it like it is. I don't mince words. And that's why they hate me down at 200 Front Street. That's why they took me out once. And they're probably scheming to try and take me out again. We'll see. This time I got a bigger blowhorn than the last time. But for those of you who are new to the channel, that's me. I'm Joe Machado. I've been doing this for over 30 years. What I mean by this is I'm also an injured worker, but I built the largest paralegal firm in Ontario, dealing exclusively with the WSIB, with over 10,000 clients from Thunder Bay, Ottawa, Windsor, and everywhere in between. And we cost the WSIB over $300 billion in $300 million in arrears and future benefits. And now I have this YouTube channel. I also have my other firm, WSIBsettlements.com, where I've developed a bunch of tools to help injured workers succeed with their WSIB claims. I want to welcome you to the channel, but I don't mince words, and I do occasionally throw out the F-bomb for those of you who have sensitive ears. But I just find that that's the only term that really sometimes expresses the true level of disdain that I have for those people and how they scheme to try and screw over injured workers. So what do they do this time? So this poor lady had an injury, and back in 2009, and they denied her claim. So she had to go all the way to the Workplace Safety and Insurance Appeals Tribunal to finally win last November, or September, I believe, of 2022. That's a long time to wait. And some of you hearing this, you probably can relate to it. Claims and cases can take a lot of time to go through the process. And but yeah, they screwed her over back then. She had to go to the tribunal to finally get some justice. And the thing is, they tried to screw over again when they were implementing the WSIB decision. They paid her benefits, and then they paid the indexing factor. She didn't agree with it. I think it was 2.9%, which every injured worker gets. If you're receiving benefits, you get that at the beginning of the year. There's supposed to be a process of how that's calculated, but the WSIB and the fat cats found a way to screw with that too. And this is why this is a really big win for every injured worker. So she said, no, I'm not going to take it. And she submitted an intent to appeal their decision. And you know what they did? They came back and said, well, no, it's not an appealable decision. Holy shit. When I read that, I thought, what the fuck? It's not an appealable decision. Every decision made by the WSIB on a worker's claim is an appealable decision. But they schemed and said no. And so through the Ontario Network of Injured Workers group, they were able to support her in a lawsuit. And they had a law office that handled the case pro bono. Oh man, this is amazing. This is so salacious. Because the lawsuit really, what it would amount in terms of dollars in her pocket for the increase in the indexing factor from January of 2022 to September 2022 or November when they paid benefits it wouldn't amount to a whole lot. But good for her. Good for her and for the Ontario Network of Injured Workers groups to support her. But before they decided to go to court, they wrote a letter to Jeffrey Lang, the president of the WSIB at the time, and asked for a meeting. This is last April. And no, didn't want to meet with him. Said, no, we're fine. We stand on our decision. Just such arrogance, just seething with arrogance. I don't think that's the way they deal with employer groups or groups that advocate for employers. I don't think so. But anyway, so the Ontario Network of Injured Workers Group said, we're not going to take this standing now. If you don't want to meet with us, you're that arrogant, we'll go to the courts. And they filed an application for judicial review. And 3 judges said, nope, to the WSIB. So this is what they used, the excuse, and how they responded to the filing of the Ontario Network of Injured Workers Groups on behalf of Ms. Grisales, and I can state her name because it's in the decision. They said, the WSIB justified its decision on the basis that the issue was a systemic one that affected how it treated all workers, not just Ms. Grisales. Therefore, it was a matter that should not proceed before the Workplace Safety and Insurance Appeals Tribunal, as the Workplace Safety and Insurance Appeals Tribunal is designed to deal with individual disputes. Where they came up with that interpretation, I have no clue. It sounds as stupid as it reads. And it was probably some schmuck, one of the fat cats, that overpaid to write that down. It's a systemic matter that the thing is it's going to come back to bite him in the ass. Because if the tribunal says, no, we agree with her, your process for determining what the cost of living is and the indexing is flawed, it goes against your own policies, and no, you have to increase it. So the floodgates are going to go open because then every other injured worker is going to be entitled to that. So yeah, in a way I agree with them. It's a systemic. But the arrogance is something that needs to be emphasized here, if I may. Their arrogance in attempting to prevent another organization that is not under their jurisdiction from doing its job. Because essentially what they said, you can't appeal this to the tribunal because, and they bypassed their own appeals branch, by the way, in how they worded that. Because obviously they knew their appeals branch was just going to do the same thing they were doing, which is to try to deny her appeal. But to block the tribunal from doing its job? Nah. And that's what the 3 panel members said. I'm going to put it up here. I'm going to read it for you, and I'm going to go through it because this is important. So the panel says, well, the problem with this submission is that it ignores the provisions of the Workplace Safety and Insurance Act, 1997, SO 1997, blah, 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 and particularly Section 126 thereof. Section 126, subsection 1, states that if there is a board policy with respect to a subject matter of an appeal, the WSIB, the Workplace Safety and Insurance Appeals Tribunal, shall apply it when making its decision. Section 126, subsection 4, provides that if the WSIB concludes that a board policy is inconsistent with or is not authorized by the Act, the WSIB shall refer the policy to the board for its review, and in doing so, the WSIB is to give its reasons for its concern. Section 126, subsection 5, pursuant to Section 126, subsection 7 and 8, the board is to give the parties an opportunity to make written submissions on the issue, and within 60 days, it is to issue a written direction with reasons determining the issue. This is pretty clear. You can't violate the Act, Section 126, that gives explicit authority to the Workplace Safety and Insurance Appeals Tribunal to determine whether WSIB policies are legal or not and to make recommendations. But they were attempting to bar the Workplace Safety and Insurance Appeals Tribunal from ever dealing with this matter by trying to take away the right of this person to appeal the fact that they gave her a less percentage in the indexing factor than that they should be giving. So then you go, the process, this is what the judge is saying, the process set out by the legislature in Section 126 of the Act has been entirely disregarded by the WSIB. Well, surprise, surprise, surprise. How often do they do that? We received no compelling reason as to why Section 126 expressly contemplates that the WSIB will review policy. It is an important principle of administrative law that absent exceptional circumstances, the parties are to exhaust their administrative remedies before coming to the court by way of judicial review. Smackdown. Go back and crawl under the fucking rock that you were under, and don't bring this stuff to the courts because it's illegal. You haven't exhausted the system in place, the procedures, the appeal system in place. You tried to take it away from the worker. And so they conclude, in view of this, I find that the WSIB decision not to allow Ms. Grisale's notice of objection to proceed was unreasonable. Consequently, it must be set aside. I further direct that this matter is to proceed to appeal in accordance with the provisions of the Act. Pursuant to the agreement of the parties, there will be no order as to costs in relation to today's attendance. Of course. I mean, can you imagine them trying to stiff Ms. Grisale's with a bill for taking them to court for being wrong? I think the judges were generous. They should have definitely fined the WSIB and awarded costs to Ms. Grisale's. But anyway, here you go. Just another one of those times where the WSIB just so flagrantly disregards workers, their representatives, due process. It's like they live in a world of their own down there. But you know what? What does this tell you? Well, the courts aren't always going to agree with them. In fact, they haven't really been challenged in the courts a lot with a lot of the crap that they do. And that's why we have the class action lawsuit that we are preparing to deal with FEL and LOE earnings and how the WSIB used their deeming practice to reduce benefits. and the whole use of their medical doctors to overrule the workers' own doctors. Oh, there's a lot of stuff on the go. And yeah, they hate me. But you know what? Plot all you want. I'm sure you want to take me out again. And I know you hate me. And the feeling is, trust me, the feeling is mutual. But you know what? I want to congratulate the Ontario Network of Injured Workers Groups that helped Ms. Grisales. And I want to congratulate Ms. Grisales. I hope I'm pronouncing her name properly. For teaching these people a lesson that's long overdue. All right, friends. Thank you for taking the time to listen again to my rant. I am excited about this one because every time that there's a win for injured workers, there's a win for all of us. As always, I've got tons of stuff to talk about. If you're not already a subscriber, please subscribe to my channel. It costs you nothing. Just click the subscribe button. You get notified every time I come out with a new video. I've got 5-10 years worth of material to talk about, over 30 years of experience, hands-on experience, dealing with these people day in and day out. And together we're going to fix the system. We're going to kick the fat cats out of the top floor. They've been there way too long. As always, friends, take care.